allow you to ask a question. Me taking science and community. I told you that you don't understand the word you are using. I have 2 dictionaries here. Sorry, Bruce. Where's the other one? Yeah, concise. Look at concise.
Before the court to maybe check the dictionary, I rise on behalf of Mr. Mngomezulu. He's asked to address the court to retract what was said earlier.
To retract what?
What was said earlier.
Me, I must retract.
No. He wants to retract what was said earlier.
He'll do it if he wants to, but I'm going to read for him the words he used. That's why I tell him that he doesn't even understand the word collusion. Doesn't, obviously.
Ms. Mokgoatlheng just asked me to explain to her what is the meaning of the word surreptitious.
Who was?
Sergeant Mokgoatlheng wanted to, yeah, she said yesterday I used the word surreptitious. I can't even remember if I used that word. I don't know where it came from. Yes, she's here.
I can help maybe.
Wait, madam, I'm sorry, out of record. That is out of record. Yes.
No, there's not of the record. This court, every man in South Africa, any woman in South Africa, yes,
Yes.
I agree with of the record.
Now, the word arose in the context of the proposition that was put by the Nisi to Colonel Holmes, that yes, that the police committed an irregularity when they did not search at case number 2.
Yeah.
We then objected and said, but there are no. It can never be an irregularity to fail to search and accuse. Then our Nisi then said the state is surreptitiously suggesting an answer to and I understand the word surreptitious to mean underhand, stealthily, in a covert, covert manner.
Yeah.
If that will help.
I think Sergeant Mokgoatlheng answered. I think Sergeant Mokgoatlheng answered.
In an improper way, in a sense that she mustn't be aware what is happening. Okay, just going to give you the meaning of the word we use. This is the South African Concise Oxford Dictionary. is the fourth edition, 2005. And this is what the word collusion means. We start with the relative of the word collude. Collude. Come means come to a secret understanding, conspire, have a secret agreement, or a secret or illegal cooperation in order to cheat or deceive others. So they say. Now this is also the modern Oxford Dictionary, which is the shorter version. Collusion. Secret agreement or understanding for nefarious purposes. Conspiracy, fraud, trickery. An agreement between two or more people, especially ostensible or potentially sweet, to act to the prejudice of the third party or for an improper purpose. Kedu is the one we quote this judgment, me and you. He has defined in the case, you will read it for yourself. In the case of Cleveland versus Cleveland and Ward, 1908 TH 197. It says it's an agreement or mutual understanding between the parties that the one shall commit or pretend to commit an act in order that the other may obtain a remedy at law as for a real injury. You can also read this case of Gabriel versus Gabriel 1945. And you can also read McLean, this is McLean 1923, etc. Now you are saying I'm a cheat for nefarious reasons. I'm colluding. I've taken an oath. If you don't know, to administer the laws and the Constitution without fear, favor, or prejudice, and to the best of my ability. I don't know Mr. Wandui from a bar of Stone. It's the first time I met him here. I've never ever had a private conversation with this gentleman. Never. You can ask him. When I talk to him is when you come together and I see him in my chambers. I'm told I'm colluding on a useless thing like an affidavit, which you say you're no longer interested in. And look at the position of a judge like me. This gentleman says, I have made an affidavit, and in the affidavit I've spoken about the two cell phones. He says, no, I'm no longer interested in them. This court, what must I do? Sit. What is the answer? I've got to say, where's the affidavit? Because I want to know whether he is telling the truth that he wrote an affidavit on the same day in which the telephones, two cell phones were picked up. Then you're saying me, I send him into the arena. Send him into the arena. What for? We don't want to say anything about it. That's why.
May I address the
No, please don't. Please. I took advice from the JP now. I told you I won't do it. Okay, Mr. Shulon, let's hear you.
One question for you. Were you present when your statement, this statement, was commissioned?
Well, the statement for this statement is a commission. Note.
Okay. Yes, Mr. Barui.
As the court pleases for Lord. Constable Mngomezulu Gustavo Viteles, I'm sorry. It was put to you this morning by Mr. Mngomezulu that you were coached outside the courtroom and that no cell phone were taken from accused number one.
So I move to this other and cell phone here to
kushiwo njalo, yes, kwasifika kanjalo.
Yes, that was what was said. That was how I was communicated.
My Lord, we seek permission to refer to what was said in the trial within a trial. Normally, such evidence is insulated from the main trial. However, the reason why we want to refer to it is twofold. Firstly, my colleagues have already freely referred to such evidence. But secondly, my Lord, and more importantly, a version has been put which substantially detracts from what was said in the trial within a trial. We are of the view, my Lord, that where the issue of credibility has been raised by the accused himself through his legal representative, then that issue of credibility should be threshed out. And we briefly want to refer to the case of State versus Muchindu, the judgment that the court has already referred to of Schutz J, 2000, volume 2, SACR 313, at page 317, paragraph F, where the court said the following: some mention was made of the question whether, even if the accused evidence in the trial within the trial may not be produced in the main trial, it may be used to cross-examine him if he offers a different version in the main trial. Here, my Lord, it's not being used to cross-examine the accused, but just to show the discrepancy, a serious discrepancy, and which has led to my colleague maligning the witness. Further on, the court held that the majority of the Privy Council answered the question affirmatively in Wong Kem Ming case at 258 to 260, and the judge refers to, so in the UK, my Lord, the court says if credibility is at stake, then the version that has been proffered in the trial, within a trial, can be referred to in the main trial. Then the court went on to hold that the appellate division left it open in Sitebe's case. It says more recently it was answered affirmatively by the Transkei Appellate Division in a tribunal in State versus Sabisa 1993 volume 2 SACR 525. In that case, it was said that if the accused departs from...
I think my concern is that I'm not so sure whether what...
Doesn't he have to finish first instead of finish? Doesn't your colleague have to finish first what he's saying?
That is the purpose for an objection.
You can't do that. You know the procedure.
That is the purpose for an objection.
No, the objection, he finishes first. Then you tell him the objection. He hasn't even finished what he's saying. He's trying to quote this case of Judicial.
Which is the reason why, because in terms of procedure, it does not need to finish as it objects first before he finishes.
Please, just sit down. That's not the procedure.
Thank you.
as a candidate,
you can object the whole day, but you've got to listen to a person until he finishes whatever he wants to say. Then you object.
But
I've read the case of
what
Wong.
the state could do
Let me
when
tell
you
you.
put something.
No, but I read the case of
Even before we
Wong.
finish, then the state will also object, and that will be good for the
No,
state.
no. I say I've read the case of Wong. Kenswich Combs it in the state versus Zuma. Okay.
then in this case of Michindu, the court left the question open. Then we refer to this case of Sabisa, 1993, Volume 2, SSCR 525, and the bench, amongst others, consisted of the former Chief Justice of Zimbabwe, Judge Mngomezulu. Then it was also the Chief Justice Beck and Golden J.A. At page 525, paragraph G to H, the following was held. Although it is wrong for the prosecution to cross-examine the accused during a trial within a trial on the merits of the main case in order to establish that the accused is not a credible witness, and this is the most important part, where the accused chooses once again to lead evidence during the trial on the merits which he led during the trial within a trial, he may lay himself open to cross-examination in order to establish credibility or otherwise. As we indicated, my lord, this is not about cross-examination, but it's about quoting passages in the trial within a trial that would counter the very serious allegation that was leveled against this witness. And as I indicated, my lord, my colleagues who accused 1 and 2 have freely referred to the evidence in the main trial. We just want to refer to about
what allegations have they?
two pages. That counsel for accused number 1 has put it to Constable Butelezi.
Oh yes.
That he was coached outside the courtroom. That that no cell phone were taken. In fact, it was even put that he's cooking. And these passages are just simply intended to show that what is being put to the witness is unfair.
Yes, Mr. William. What's your response? Who's coaching him, you or me?
Well, it wasn't specified. It just said he was just coached outside the court.
Okay.
First, my daughter was not even aware that the constitutional changes will take a stand. I was under the impression that my colleague Adv Mngomezulu was going to complete this examination. Number 2, I heard from my colleague Mr. Wasiki that they are calling changes, but there was no mention that they are calling the police officer. The changes they are calling is the one that sent money for dance. I was under the impression. To my surprise, hence when I stood up, I objected to the evidence of the calling of Constable Butelezi, but I considered when the procedure was properly followed that he was a candidate to be led in the retrial. But my lord, the fact that I made such allegations or assertions to the witness is because some of the things that I said to the witness were said to Sergeant Mokgoatlheng, and they were not taken up as seriously as the state is now and taking such submission. even the issue of cooking was addressed to, was canvassed to Colonel Hose on the basis that when he made his statement, he referred to one statement, one cell phone. And when I cross-examined Sergeant Paula, she then talked about it as 2 cell phones. And I asked her why such cell phones were not mentioned during the trial. So, soon thereafter, Colonel Holmes made a supplementary affidavit. In the first affidavit, he mentioned only one cell phone, which is 079-379-37-0137. So on the supplementary affidavits, there are 2 cell phones that are mentioned. The one with 060 and the other one with 071. I also canvassed that with Sergeant Mokgoatlheng to the extent.
Sorry to interject, but Mr. Alou is concerned about the basis used, not about the innards of what you said. It just takes exception that you are saying to him, he coached this witness. Am I quoting correctly? That's what that's what your learned colleague feels, that his dignity is impugned.
No, I don't get me just. If I was properly understood, I said I was not told that Constable Davis was going to testify.
No, that's not the issue.
Yeah.
They say he was coached outside the passage. You said that.
But I never specified to say he was coached by.
Okay, fine.
I never specified
Fine.
any name. I just put it
And then the other stories about this gentleman being told that you are not talking about traffic tickets.
Now, may I withdraw that one? I wanted to withdraw it to apologize and say I wasn't supposed to say it, because I didn't want to justify what you said, which invited me to say such words.
No, but you are used to saying this. Everybody is cooking the evidence. Even this judge is siding with the prosecution and colliding with the court. I don't know, you want to be accepting me with section 317. Let me read it to you. You can sit down. Because you are not addressing the language you used against your colleague, Mr. Alou. You are saying now, you never mentioned anybody by name. I don't know. Maybe Nelson Mandela will wake up from his grave and coach this witness. Because anybody knows you are referring to the state.
No, that's an inference.
Yeah.
I never.
The only reasonable inference. Only. The only person who's using evidence on behalf of the state is Ibande and
the investigating team, my lord, is not the persons that you can correlate. No, I'm not making a reference to this paper. May I not be misquoted? I said that you can pay that on record. I never paid.
Even me, you were going to say one day to the others, you never said, I'm colluding.
My lord, you once made mistakes and you apologized.
Yeah.
But now I'm
But I don't swear at anybody.
No, but I made mistakes.
You're swearing at me.
And
you're calling me a cheat. You're calling me a nefarious character.
But my lord, you never afforded me an opportunity to retract and to apologize.
There's 317. You can't let him be with this 317. Let me tell you what it says. Section 317, special entry of irregularity or illegality. 1. If an accused is of the view that any of the proceedings in connection with or during his or her trial before a high court are irregular or not in accordance to law, he or she may, either during his or her trial or within a period of 14 days after his conviction, or within such extended period as made upon application in this section referred to as the application for condonation, on good cause, be allowed and stating with respect that the proceedings as alleged are irregular or not according to law, and such a special entry shall upon the application of such a special entry be made unless the court to which the judge to whom the application for a special entry is made is of the opinion that the application is not made bona fide, or that it is frivolous or absurd, or that the granting of the application would be an abuse of the process of court. So you can make it. I can tell you, in my 22 years on the bench, nobody has ever succeeded with an entry in terms of section 317, ever. Not this judge. Okay, you can make it. Anytime that I'm wrong on the law, I said this and this and that and that and that. I still want to see it. Me being wrong on the law. That's said. Are you still going on?
I think there was an objection from Advocate Mngomezulu.
This objection is what now?
Yes, my objection was on the basis of the fact that we are expecting this to re-examine the witness in the procedure. But now he embarks upon addressing the court and he starts to prefer an argument without having noticed the other parties that he will be embarking on that kind of a process.
Okay.
That was my point of objection.
Sir, do you have any reason?
So, may I address the court? My Lord, during Advocate Valois' address to the court, he says both myself and Mr. Mngomezulu have freely referred to the evidence in chief. My Lord, I submit I've never done such. I concentrated only on the 4 days, the 18th, the 19th, the 22nd, the 24th, about the movement of accused number 2 to these places.
I heard it. That movement was alluded to in the trial within the trial.
Yes.
Yeah, so what's the problem?
Yes, but I never got into the merit of...
No, but he says in the trial within the trial, there was a person called Mokgoatlheng, etc., etc.
Let's hear him and then I'll revisit my objection.
Okay, fine. Yes, sir. They say we don't have any...
Yes, reference was made to the ABL, to the evidence of Mokgoatlheng, of Jonathan, what transpired at Moroka and Flores police station.
Yeah, that was in the trial within the trial. Yes. So do you have any reasons?
Yes, I do, Manoj, but I just wanted to quote this passage in the trial.
No, fine. I think you have done so. Okay.
But can I do so?
Yeah, no.
Yes. These are the proceedings of the 5th of February 2024, and Manoj, this is based on the proposition that was put to the witness that no cell phones were found during the arrest of accused number 1, and that this is cooking. We just want to refer to the record of the proceedings of the 5th of February 2024, page 5 February 2024, page 12. This now during the evidence of accused number 1 during the trial, in a trial, and we quote from line 3, Mr. Mngomezulu, okay. Can you please tell the court about the way you were arrested on 30 May by who? Then accused number 1. On 30 May, it was during the course of the day. We were just sitting there with other gentlemen in a certain house on certain premises. Mr. Mngomezulu, yes. Accused number 1. We were standing inside the premises against the wall. Mr. Mngomezulu, yes. Accused 1. A lot of police officers appeared. They were carrying rifles that they pointed us with. Mr. Mngomezulu, yes. Accused number 1. As they were pointing us with these firearms, approaching us, they were then dishing out instructions, orders, lie down, and swear words were also used by accused number 1. Then Mr. Mngomezulu, yes. Accused number 1, as a result of shock, because we were shocked, we lay down. Mngomezulu then. Accused 1, as we are now laying down, one of the police officers came to us and asked each one of us individually who our names were. Mr. Mngomezulu, before you proceed, how many were you? He says, accused 1, 3 of us. Mr. Mngomezulu, proceed then. Accused 1. As they were asking us, or as he was asking us individually, he also asked me, and I told him who my name was. Mr. Mngomezulu, yes. Accused 1. They asked me where I originate from. Mr. Mngomezulu, yes. Accused 1, I informed them that I'm originally from Emahlabatini. Mr. Mngomezulu, proceed. Accused 1, one of them pulled my hands and take them to the back and then placed handcuffs on me. Mr. Mngomezulu, yes. Accused 1 then held me, that is now held as my hands were tied together using the handcuffs, held the handcuffs and picked me up. Mr. Mngomezulu, yes. And this is the most important part, my lord, and there is a reason why I want to refer to the record. Accused 1, as I stood up, I was then searched, and then 2 of my cell phones were taken, a Samsung as well as a smaller phone. Now, there's a reason why we wanted, this witness was now maligned, and the proposition was put to him that he's putting his evidence, whilst the accused himself said that in this evidence, in the trial. Now, coming back to the re-examination, Constable Buthelezi, you've referred to Exhibit H, your statement. And my lord, during the adjournment, we tried to put our heads together to decipher as to what that word refers to, the Johan, and I think my colleagues can bear me out. It refers to a place where the affidavit was commissioned.
Yeah, the affidavit was commissioned. The fact that you can't decipher whether it was commissioned by Adv Mngomezulu or Mokgoatlheng, it's not again with it.
But it refers to the place where it was commissioned.
Fine.
You refer to paragraph 6 of the affidavit. If I can ask you to proceed and refer further to that paragraph on the next page.
Looking the better paragraph 6,
starting from the sentence, the cell phones.
Okay. Sentences to the cell phones.
Okay. The cell phones were black and gray. Black and gray, name unknown. A gold Samsung Galaxy Grand Prime Plus. A firearm. Okay.
Now, this was because it was put to you that there were no cell phones that were found on the person of the accused during his arrest on the 30th of May 2020.
Sure, can you go back?
Yes. So it was put to you that no cell phones were found when the accused was arrested. What is your comment now in light of the passage that we just put on record?
Sure, I'll come and say for natural and discuss a board, so that we can.
No, iphutha akhona ama cell phone atholakala kumsolo.
No, that is wrong. There were cell phones that were found on the accused.
And can you just once again repeat the date on which you made the statement and the time?
Uphinde futhi ilanga lawa nesikhathi owenza khona statement.
Statement ngicabanga ukuthi ngasenza entathakusa kuzosa kube yi-31st ekuseni.
I made the statement in the early hours of the morning of the 31st.
It was also put to you by Mr. Mngomezulu that you were asked as to whether you can remember what was on the J50, and he then put a proposition to you that you carried out something you were not sure of, and furthermore that the J50 was unlawfully obtained.
So when J50 basebethi wenze into ongayazi
Weqiniso.
le J50 ayitholakala ngokusemthethweni.
Weqiniso lokho.
That is correct.
We just want to refer to Exhibit TT, if you can just, which is already on record, Exhibit TT. If you can just identify it and just read the first paragraph.
So the paragraph uqala
La ibhala khona station police station Tembisa South, case number 217/3/2019, Muzi Sthemba Sibiya, unknown male. Bese my yehla la ku application under section 43 Act 51 of 1977 for a warrant of arrest. Bese its application is hereby made for the issue of a warrant for the arrest of Moses Sthemba Sibiya in a charge of dealing in drugs. Bese iba nosuku la ethi khona, there being from information taken upon a reasonable suspicion that he committed the alleged offense on or about the 19th day of March 2019 in the district of Tembisa. The said Moses Sthemba Sibiya is at present known or suspected on a reasonable grounds to be within the district of Ekurhuleni, Mpumalanga, Yasisai.
And the date?
It date assignwe ngayo ithi 2019-12-05.
the date on which it was signed, it was 2019-12-05.
05.
And just lastly, it was put to you that Surgeon Mokola testified that she kept the 2 cell phones at Araton before they were handed in the SAP pit. Now the question is, do you know where the cell phones were kept after they were confiscated and before they were handed in the SAP pit in store?
Uthosodwa ngokuba wathi kuthe wayegcine la cellphone amabili endaweni ese-Araton ingakafakwa kwe-SAP. Uyazi yini nolazi yini ukuthi la cellphone lawa ayegcinwephi kusukela ngesikhathi ethathwa ukuba solwa nalapho eseyofakwa kwe-SAP 13?
Cha, bengingazi ukuthi akuphi. Ngagcina ngonikeza yena.
No, I have no such knowledge. The last time was when I handed the cell phones over to Sergeant Mokgoatlheng.
Thank you, Madam.
Yeah, no problem. Police witness. Say, me, I apologize for the impugn of your dignity in this court in which I preside.
Sekholisiwe isithunzi sakho kule nkantolo.
I was not taught that.
Zange ngifundisa ngale nto.
Okay.
Ngiyabonga kakhulu.
My apology.
Thank you, my lord.
Yeah, thanks. Okay.
But as a court case, my lord, tomorrow it's a public
We are
holiday.
sitting tomorrow.
Yes, it's a public holiday.
Oh, is that what it is?
Yes. We've informed my colleagues on the left-hand side that we made our best endeavors to get short witnesses for Thursday and Friday, but we were not successful. The next witness that will be coming is Ms. Pinky Fantelike on the 3rd of June, that is now Monday. And we request that the matter then be adjourned to Monday to commence with the evidence. Evidence is going to be very long. There are a lot of documents that have to be made copies of, in light of the fact that some of my colleagues have requested hard copies. It will take some time, my lord, to make those copies.
Please Monday we will start.
Yes, no, definitely with permission. The electronic versions have already been given to my learned friends. Just need to make hard copies.
Okay, I'm told there are reasons why we should sit tomorrow on Thursday and Friday. Because the state did not prepare any witness for those 2 days. Someone can see the way says let us convene again on Monday.
Kuthiwa-ke kuhleliwe ukuthi kuzohlanganwa ngomhlaka 3 Msombuluko ngoba abekho ofakazi abalungisela ukuthi bangeza kusho ukuthi ayihlali inkantolo kusasa nangoLwesine nangoLwesihlanu.
Okay. When Mr. Mngomezulu, you know there are judges who have been impeached on minor things than the one you are accusing me of. For instance, my brother, Judge Frog, was impeached on the basis that he attempted on his by influence constitutional court judges when Langa was the CJ in the Senator of the CPC. And that gentleman was impeached. My other brother, who we grew up together, Judge Mokgoatlheng, was impeached for allegedly being drunk and saying certain things. Now, what you are accusing me of is worse than that. Okay.
May I apologize? May I return and apologize?
Okay, fine.
I consulted with my conscience.
All right. Monday then.
Paparazzi. Paparazzi.